Hello and very good evening, everyone. I hope that everyone are still staying safe, doing great wherever you are now. Welcome again to our second episode of the Strata Talk Shows by Excel Academy. So my name is Ami. I'm your host for today's Strata Talk Show. And as you know that this Strata Talk Show is brought to you by the Excel Academy of Real Estate. So joining with us today is the Mr. Patrick, and today on the second episode, we will be discussing and talking about a very interesting topic, which is the management committee members and office barriers overstaying. Hi, Mr. Patrick, how are you doing today?
Okay, good. Thank you very much.
Okay, thank you so much, Mr. Patrick, for your time and talking with us and sharing your thought and view on these very interesting topics. So, guys, if you have any question to ask to Mr. Patrick, feel free to write your questions on the Facebook comment below. Hopefully, we will entertain your question at the end of our talk show later. Okay, so without wasting any more time, please join me in welcoming Mr. Patrick.
Okay, thank you very much, Encik Amir. Okay, good evening to all of you. Thank you all for joining in this evening. Today's topic last week is a sort of continuation from last week. Last week we spoke about attending meetings and voting at meetings, and we looked at various statutory provisions. Today we are looking at the election of office bearers. And there are some confusion about election of office bearers, and more relevant to us today, the practical problems that arise is office bearers who overstay their welcome. And what do we mean by that overstaying of their welcome? And if that means they are staying beyond their term of office. There are those who will keep on saying, I'm only doing a voluntary service, I'm trying my best, I do my very best, I'm helping, but they stay beyond their term of reference. What happens in such a situation, and how can we actually overcome such a problem? Now, let's start by saying that in this process, we need to look at a number of resources to find our law in this area. Number of resources. Our starting point is always the Act, the Strata Management Act 2013. Now, there are three relevant sections for us here. The first is Section 22, subsection 2. Section 22, subsection 2 talks about the Joint Management Committee. Now, before we even go into that, when vacant possession has been given to the purchasers, parcel proprietors, the developer will usually manage the place until 12 months after vacant possession is first delivered. This is called the developer management period. There is no provision for any kind of meetings. The developer just manages the place. 12 months after vacant possession has been given, 1 month later, the first AGM of the joint management body has to be convened. And at this joint management committee, as a joint management body, it consists of all the parcel owners at that time who have purchased the property and who have got vacant possession of the same. They form the joint management body. So the joint management body consists of all the parcel owners. Now, practically and naturally, the parcel owners cannot always be coming together to meet to make decisions. Therefore, in this case, this joint management body must elect committee members. They must elect committee members to represent them, give them the necessary directions how to govern the place, and allow the committee to exercise the powers of the joint management body. The Act provides there shall be not less than 3 committee members and not more than 14 committee members. Now, at the first AGM and at subsequent AGMs of the JMB, this is one of the items in the agenda for the meeting, the election of committee members. Please note that the JMB does not elect the chairman, secretary, or treasurer. They elect the committee members. And the law provides that immediately after the AGM, all elected committee members have to choose from among them the chairman, the secretary, and the treasurer. Now, in the JMB, the developer automatically is a member of the JMB. The developer is also automatically a member of the JMC, the Joint Management Committee. So take note, there's a very important point I want to raise to you all later. I want to highlight to you all that the JMB at the AGM only elects the committee members. Immediately after the meeting, the committee members will sit down and they will choose their chairman, secretary, and treasurer. The chairman is only chairman of JMC, not the chairman of JMB. At every AGM, the floor must choose a chairman to chair the meeting. Now, the same applies to management corporation. Once 1/4 of the total share units have been issued with strata titles, the first AGM of the management corporation must be held, and at the first AGM, they will choose the management committee. And immediately after the AGM, the management committee will choose from among themselves their chairman, their secretary, and their treasurer. This is provided for in section 56, subsection 1. So section 22, sub 2 is for JMB, JMC. Section 56, sub 1 is for MC, management committee. And the third section is section 63 for the subsidiary management corporation or committee. Right? So 3 sections, 22, 56, and 63. That is all the statute has to say about office bearers and committee members. Next, we need to go to the second schedule of the Strata Management Act 2013. The second schedule in item 2 under the heading of Constitution of Management Committee, in item 2, sub 4, sub 5, and sub 6 talks about the term of office. And for the chairman, the secretary, and the treasurer, the term of office is for 2 consecutive years. For the rest of the committee members, it is 3 terms. There's a slight difference in terminology. For chairman, secretary, and treasurer, it is 2 consecutive years, which means 24 months, maximum 50 months, because from one AGM to the next AGM, you must not allow more than 15 months to lapse. So although ideally it should be held within 12 months, it can be held within 15 months. So it may be 30 months. So anywhere between 24 to 30 months. But for the committee members, it is stated to be term. 3 terms. All right. Then the rest of that item 2, from item 2 sub 7 to sub 13, talks about eligibility and non-eligibility of persons to stand for election as committee members. Item 3 talks about vacation of office. This vacation of office is automatic vacation of office, right? So if you resign, you automatically vacate. If you're declared a bankrupt, you automatically vacate. If you sell off your property and you're no longer an owner, you automatically vacate your position as a committee member or an office bearer. All right, this is for that part. I do not want to go too deep. You all can read what are the eligibility requirements, what are the conditions under which they can be elected as committee members. Now, item 8 in your second schedule states, notwithstanding any defect in the appointment of office bearers and notwithstanding any disqualification of any of the office bearers, all decisions of the joint management committee or the management committee or the subsidiary management committee shall be valid. Let me repeat that again. Despite any disqualification, despite any defect in the appointment of any of these office bearers, all decisions of the committee shall be valid as if there were no disqualifications and no defects. However, this is subject to a very important caveat, and that is the committee must have acted in good faith. In good faith. That is what it says. Now, what else? What else does the act or the schedule have to say about the election of office bearers? The answer is nothing. The answer is nothing. There is nothing else the statute has to say about the election of office bearers. However, there's nothing. Let me tell you that. There is no punishment, there is no offense. You can check section 22, section 56, and section 63. Please let me know if you find there any subsection saying anybody who breaches this section is acting against the law and shall be fined, etc. You will not find a direct law on that. That is what gives the boldness to these office bearers to stay on despite the fact that they have overstayed their visit. There are, however, indirect ways of dealing with these problems. But before that, we have looked at the Strata Management Act 2013. We looked at the second schedule, the Strata Management Act 2013. Next, I would like you all to look at the Strata Management Maintenance and Management Regulations 2015. The Strata Management bracket Maintenance and Management Regulations 2015. There is a regulation 33. Okay. Number 4, you need also to look at the third schedule of the SMA 2013. Right? The third schedule of the SMA 2013. Number 5, you need to look at the Strata Management Compounding of Offences Regulations 2019. Now, this regulation, which was enacted in 2019, gives you a list of all offences under the Act which are either compoundable or non-compoundable. And sections 22, 56, and 63 are not listed in the list of these offences. The Strata Management Compounding of Offences Regulations 2019. So, what have we? The Act does not stipulate the term of reference for office bearers. The second schedule stipulates that chairman, secretary, and treasurer cannot hold office for more than 2 consecutive years. And for other committee members, they cannot hold office for more than 3 terms. I have cases where we have people who have been chairman or secretary or treasurer, and then later they become, after finishing their 2 years, they become ordinary committee members. Can that be done? This is where we need to be careful. I told you a very important thing. At the AGM, members only elect the committee members. You cannot be a committee member for more than 3 terms. Now, it's the committee members who choose their chairman, secretary, and treasurer. So once you have been a committee member for more than 3 terms, you're automatically out. Right? So you can be a committee, you can be a chairman for 2 years, maybe you can be a committee member for 1 year. That means your 3 terms are up, is over and done with. But you cannot say, I want to be chairman for 2 years, I want to be a committee member for another 3 years or 3 terms. That'll make it 5. You cannot be a committee member for 5 years. That's not allowed. So, what is sad, or maybe shocking or surprising, is that the Act does not provide what should happen in the event the member overstays. Now, you might suggest, if the member overstays, the committee member overstays, or the chairman or the secretary or the treasurer overstays, then they should be automatically disqualified. Sorry, that is not provided for in the second schedule. The second schedule provides a list of automatic disqualifications. Overstaying is not listed as one of them. It is not. So, how do you actually deal with a person who has overstayed? We know that you generally have 4 resources to go to. Your resource number 1 is to call for an EGM or raise this issue at the AGM itself. So during the AGM, if a person who has been a committee member for more than, it's already completed his 3 terms, wants to be re-elected or volunteers to be re-elected, you can put up your objection and say, no, cannot, the law provides this. Or you can call for an EGM to ask that persons to step down. Alternatively, to vote the person out on these grounds. Secondly, you can lodge a complaint with the Commissioner of Buildings. It's a second option. Your third option is to bring the matter up to the Strata Management Tribunal. And last, you can go to the court, which is the most expensive. Right? These are the ways you can do it. Now, what is the procedure for doing it? It's a very interesting thing that we look at when we look at the procedures that should be adopted. So, now, you can easily bring it up during the AGM or the EGM. You may or may not get outvoted. You may or may not be successful in this process. But there are cases in the courts which say that you should try and exhaust all internal proceedings as far as possible before coming out to the courts. The courts should be the last resort for everyone. So, you should attempt to present a motion in the AGM or the EGM, or you should have it recorded that you object to Mr. A or Mrs. B being re-elected as a chairman, secretary, treasurer, or committee member because they have completed their term of office. If that is not successful, you can lodge a complaint to the Commissioner of Buildings. What can the Commissioner of Buildings do? Now, there are several things that the Commissioner of Buildings can do. One is the Commissioner himself can call for an EGM and determine the item to be discussed at the EGM. So the Commissioner can call for an EGM and say, all right, the items are Mr. So-and-so has overstayed, he should be removed. Mrs. So-and-so has overstayed, she should be removed. Miss So-and-so has overstayed, she should be removed. And then the floor can make the decision. Question: can the COB remove the committee member? The answer to that question is no. Right? The answer to that question is no. In 2018, the COB sacked or dismissed the entire committee members of Riviera 3 apartments in Ampang Jaya. So the COB for Ampang Jaya removed them over certain issues. The chairman was very unhappy. He challenged this in the tribunal, and the tribunal chairman, the famous Mr. Roger Tan, made the decision that the COB is a creature of statute. He does not have the power to remove the committee members. So, at the most, the COB can call for an EGM and allow the members to remove the office bearers. Now, if you find that that is not effective, maybe the entire JMC, the entire MC is conspiring together to stay in office. All of them have overstayed. All of them do not want to go out. What do you do next? Then there must be some reasons for suspicion. The COB has the power to appoint a managing agent to manage the place. When the managing agent comes into the picture, who must be a disinterested party, must have no connections whatsoever, then the managing agent will supersede the JMB or the MC, the committee, and he will manage and he will make the necessary reports to the COB. So this can be done. Section 86 provides for this. As far as the COB calling for, the members can call for EGM. Please note, second schedule, item 11 can call for it. So the COB can call for an EGM. The COB can appoint a managing agent under section 86. But the COB has no power to remove any committee member who overstays. Number 3, apply to the Strata Management Tribunal. If you look at the Strata Management Tribunal regulations, you'll find that one of the powers or jurisdiction of the Strata Management Tribunal is to nullify resolutions at meetings. So, since the chairman has a power to nullify a resolution, any resolution re-electing a committee member, office bearer who has overstayed, can be nullified at the Strata Management Tribunal. That can be done. So that's the next way of doing it. Finally, of course, the last option is to apply to the court for injunctions to stop a JMC or a MC from acting because they have overstayed, or to remove them by order of court. The High Court has the power to do so by way of judicial review. So you can bring a judicial review action or an originating summons to remove them. Also, if an MC has already been established as a management corporation, you can apply under Section 76 of the Act for the court to appoint an administrator to administer the place according to the terms and instructions of the court. These are the things that can be done. You can bring, of course, indirect action. For example, if the JMC does not call for a AGM within the 12 to 15 months period, this is an offense. If the JMC or the MC does not provide the accounts at the AGM, this is an offense. So if indirectly you want to bring an action, this will be the only way. But if accounts are presented, AGM is held at the relevant time, then it's not an offense. Overstaying is not an offense under the Act, not directly anyway. And the only remedy is for the resolution to be nullified by the tribunal. So, you're put in a very difficult situation. You're put in a tight rope, actually, because it's not easy then to remove people from their position as chairman, as secretary, treasurer, or in other situations. It may come as a surprise. It came as a surprise because I was acting for a JMB or JMC, where it was claimed that the JMC members had overstayed. But in that case, they had actually obtained a court order. And while some people were challenging, and they were saying, it's an offense and things like that, I told them, can you please point to me where does it state overstaying is an offense? Or where does it state that if you overstay, you will be automatically disqualified? Because we cannot see that in the Act. We cannot see that in the schedules either. So we have to be very careful before you bring any action against anyone. If you're going to claim that they have overstayed or anything of that sort. Let me just show you that item number 3 in the second schedule to the Act just says committee members shall vacate, chairman, secretary, treasurer, or committee member shall vacate or deemed to have vacated if he resigns, if he dies, if he becomes a bankrupt, if he is no longer a proprietor, if he has been convicted, not accused, convicted on a charge in respect of fraud, dishonesty, offense under any law relating to corruption, offense under this Act, then it must be an offense, or any other offense punishable with imprisonment for more than 2 years. If his conduct, maybe F can be applicable by a long stretch of the imagination. If his conduct, whether in connection with his duties as a member or otherwise, has been such as to bring discredit on the management committee, which is very, very general. If he's of unsound mind, absents himself from meeting, right? And things like that. If it's default of his charges, right? So maybe the only two provisions in that item 3 can be paragraph F and paragraph L. Paragraph F says if his conduct, whether in connection with his duties as a member of the management committee or otherwise, has been such as to bring discredit on the management committee. Overstaying can be said to bring discredit, but it's not easy to prove. L says in the case of a member of the management committee, if he commits a serious breach of the bylaws and has failed to remedy the breach, again, it's not going to be easy. It's not going to be easy. So, this then is the position that we are in as far as committee members, office bearers are concerned, where they have overstayed their visit. Okay, I think with that, I will stop here for a while. And if any of you have any questions, please refer it to Mr. Amir. Mr. Amir, back to you. Thank you.
Yes, thank you so much, Mr. Patrick. I hope that everyone's received as much as input as I have. So now we are on to the Q&A sessions, and we can see there is a lot of question coming from the participants tonight. So I will pick one of the question first, and the question is coming from Mr. Teo. And Mr. Patrick, the question are, can the term by extend to stay 2 or 3 years per terms?
Right, that's a very interesting thing because the word used is term, but if we put it into its proper context, right, its proper context, what it means, I think, for committee members is there cannot be more than 3 terms. It doesn't use the word consecutive. The act itself and the regulations also provide that there must be an AGM held every year, and all committee members have to resign at the AGM and they may be re-elected. So when we say one term could be a stretch of 3 years. That's one term. But that will mean that you can stay on till 9 years or 6 years for that matter. That is not the intention of the law. The intention of the law is you should not stay for more than 3. So when they say term, I think it takes about once a year. 1 year is a term, and 2, 3. So they use the word term because you may take a break. You may stay 1 year, 2 year, take a break, 1 year, come back for another year. That will make it already 3 terms. Whereas for chairman, secretary, and treasurer is 2 consecutive years. There's a difference there. I hope that answers the question.
Okay, great. Yeah, I hope Mr. Patrick has answered your question, Mr. Teo. Okay, the next question is coming from Mr. Jai Ganesh. Thank you so much, Mr. Jai, for your questions. So the question is, Mr. Patrick, if so and so if elected anonymously by the floor, despite them exceeding their term, can this be still challenged? And after the COB call for an EGM to table this motion, the floor agrees to elect the exceeding members. What's next?
All right, that's an interesting question. While the statute, the whole idea of strata management is to allow the owners to manage themselves. So by right, if you ask me, that philosophy that you manage yourself means some leeway should be given to the members to manage themselves. However, having said that, unfortunately, in Malaysia, we have not come to that extent of fully allowing people to manage themselves. So you find, for example, compared to the United States or even in India and in Australia, in these countries where their strata management has already been quite advanced, they have even disciplinary committees within the management itself to deal with discipline issues, nuisance issues, to resolve issues between neighbors. They have that. But in Malaysia, we do not have any such kind of leeway, any such kind of mechanism to allow the JMB or the MC to resolve their own issues. So there's also the provision of statute that the nobody is allowed to contract out of the Strata Management Act. So you cannot contract out of the Strata Management Act even if you unanimously agree to something and it is goes against the law, then it is against the law. Such unanimous decisions can still be nullified. They can be nullified. So there is no issue about it. And also that nobody, and I mean nobody is allowed to make any bylaws or house rules which goes against the act. Formally, in the beginning, when the Strata Titles Act was passed in 1985, every Strata project had their own house rules, and they call them council members. Then in 2007, of course, we saw changes coming in under the Common Property Act and all that. But now the rule is no bylaw, no regulation can go against the Strata Management, Maintenance and Management Act 2015. So cannot. So therefore, my answer is, in theory, even unanimously you go against the law, is invalid, it can still be nullified. I hope that answers the question, Mr. J. Ganesh. Thank you.
Okay, great. Thank you, Mr. Patrick. And the next question is coming from Steve Ongs, and the questions are: in a situation nobody wanna be a volunteer office bearers or committee, even they still remain elected the same JMC after 2 years, should write the letter and minutes of the meeting to COB. Thank you.
Right. What should be done actually is the um, when anything like this happens. Now, I was dealing with a case like this in Ipoh. Bercham Noah Ipoh is the first gated and guarded community in Ipoh, where the developer wanted to call for a AGM to appoint the JMB to take over. And then they said, while there were few people who were willing to volunteer, it was not enough, and therefore the developer continued to maintain the place after that. Now, while I was acting for some of the individual house owners, I brought it up to the attention of the court that the developer should have notified the COB and should have asked the COB to have taken over the management and maintenance of the place. So the COB can appoint a managing agent, and that managing agent can come in and take over responsibility for the place. They have to find out why nobody wants to take responsibility. It's very important to find out why. You see? So this is very important. It is not proper for the committee members to say nobody wants to do the work, let us continue to do the work. Because if we continue to do that, then suddenly you'll find one day one new owner who has just purchased, who has no knowledge of what happened before, he goes through the minutes of meetings and he says, hey, what are these guys sitting here for 5 years? And then he starts creating a problem. Then becomes an issue. It is no defense on your part. Right? I hope that answers the question.
Okay, great. Thank you so much, Mr. Patrick. I think there is another question from Mr. Lee, which is, what if no resident are interested to be MC members or a school, and MC unable to form? What will be the next step and needful to proceed?
Okay, like I said, you can go to the COB and ask the COB to appoint a managing agent, or we can go to the court and ask the court to appoint an administrator. If it is a gated and guarded community, which means it's a land strata, and nobody is actually interested, you can actually apply to cancel the strata and turn the gated and guarded community back into an ordinary land title. This happened in Sramban too, which was a gated and guarded community. Nobody was interested in managing the place, and ultimately, what they did was to cancel off the strata title, break up, open the gates, just open the gates, all surrender the strata titles, and all are given land titles. Common property is handed over to the council. That's it. That'll be the ultimate solution if it's a gated and guarded community. If it is a building, of course, this cannot be done. The only other solution is managing agent or administrator.
Okay, great.
I mean,
Thank
just,
you.
just to elaborate a bit on that, let me tell you that there is the statute actually stops there, doesn't give a proper resolution to the problem. At least I would have thought the statute, from the questions that you all have asked, is a very common problem. The statute should have at least say that the existing committee members can actually go to the COB or go to the tribunal and get an extension for them to work on an ad hoc basis until there are others to take over. But such a provision is not provided for. Thanks.
Okay, great. Thank you so much, Mr. Patrick. And next question is coming from To Hong Po. And the question is, can it be 9 months or lesser per JMB term?
Uh, I do not quite understand this question. The JMB, all right, first of all, is a temporary body. The JMB is brought into existence once vacant possession has been delivered from the first person who gets the key, vacant possession. 12 months is given, and at the end of 12 months, the following within 1 month after that, the first AGM of the JMB must be held, and the JMB will take over. The JMB will constitute of all purchases of parcels at that time plus the developer. However, the statute also provides that if at the time of vacant possession the developer has already applied for strata titles and the strata register book has been opened, this means the MC has already been formed. In such a case, you will not have a JMB. Likewise, if shortly after the first AGM of the JMB, let's say in less than a year, the strata register book is open, 1/4 of the share units have been issued, very efficient developer and very eager purchasers who want their strata titles, the JMB will have to come to an end shortly after that. But the statute does not provide for shorter terms. The statute just says at every AGM, the JMB is elected. And the JMB and the AGM must be held in any event not later than 15 months from the previous AGM and every calendar year. So it's supposed to be 12 months, but not later than 15 months. Right? That is one thing. And you resign and you actually get elected at these AGMs. Also keep in mind that the accounts will be prepared for 1 year. And the accounts are also presented at AGMs. So if you talk about 9 months, 8 months, 7 months, the accounts will not tally because accounts are supposed to be done for 1 year. So it should be 12 months to 15 months, not 11, 10, 9. It should not be done earlier. Thank you.
Okay, great. Thank you. So next question is coming from Mr. Calvin. Okay, hi, Sifu Patrick. What do you think of second schedule, subsection 2.5? The office bearer shall not hold 2 consecutive years instead of term.
Mr. Kelvin is my long-term person. Huh? I know him quite well. All right. Okay. To answer the question from Mr. Kelvin. Okay. Two consecutive years. It means that you cannot hold office for more than 24 months or 13 months and not terms. They don't use the word terms because they talk about cannot hold for more than 2 consecutive months, 2 consecutive years is what they say. Then you can take a break and then you can come back later. So you can take a break after 24 months, step down, let somebody else take over, manage the place. After 1 or 2 terms, you can come back again for another term. That there is nothing wrong. Mm. But for committee members, they use the word term. It's not consecutive, just 3 terms. They cannot be committee members. I hope that answers the question, Mr. Kelvin. I don't know why he calls me Sifu all the time.
Okay, great. I hope yeah, Mr. Patrick has answered your question, Mr. Calvin. The question before Mr. Patrick, which is the can it be 9 months or lesser per JMB terms? He's actually referring to AGM held every 9 months or shorter.
The AGM should be held only once a year, once a calendar year, uh, because the AGM is not only about election of members, it's also about preparation of the accounts. So the accounts should be on a 1 year basis. So if the accounts is on a 1 year basis, then you cannot be having the AGM 9 months, because then your accounts will not tally for 1 year. Your accounts will come lesser. So because you must understand, it also involves accounts. It also involves the budget, which must be presented at the AGM, and the budget is supposed to be for 1 year based on your accounts. As such, it's not practical to call for AGMs 9 months. It's not practical. How would you balance it with your budget? How would you balance it with your audited accounts? Maybe for the first year might be short, but subsequent years it has to be once every 12 months, not later than 15 months. I hope that answers the
Okay.
question.
Yep. Correct. Yep. I hope Mr. Patrick has answered your questions, Mr. To. So there is another question from Mr. To again, which is, can the developer appoint somebody not from their company, either director or staff, to chair the first AGM?
Okay. Can the developer appoint somebody to chair the first AGM? You mean the first AGM of the JMB? Um, I suppose they can do it. I don't see anything wrong in doing it, but if they get someone to do it, because the Act also provides that the developer can have what you call appoint people to manage the place. They can appoint people to maintain the place, and they can allow them to 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 chair the first AGM as long as all the rules and regulations are followed. We do not see any issues arising here. So we don't see that as an issue actually.
Okay, understand. Thank you, Mr. Patrick.
Mm.
Okay, we have a lot of questions actually, and the next question is coming from Bella, Donna Bella. Within how many months developer has the duty to convince the MC first AGM after the expiration of the initial period?
Okay, we are talking about the initial period. That means we are assuming. Okay, now there are two. Before I answer the question, there are two schemes which are presented in the. Let me explain. There are two schemes that are provided in the Act. Scheme one is where you have the developer managing the place, and he has already applied for strata titles. The strata register book has been opened. Now you understand, when the strata register book is open, the MC automatically comes into existence. Right? The MC automatically comes into existence. The pejabat tanah dan galian will issue, the strata director will issue a certificate saying that the Strata register book was opened on this date, and therefore the MC has come into existence. But the MC's first AGM can only be held when one-fourth of the share units for the entire project has been issued. So that will be this initial period. Now, if you were to look at section 57 of the Act, it says that it is the duty of the developer to convene the first AGM within 1 month after the expiration of the initial period. So this is the direct answer, right? Within 1 month. Now, this is one scene where you have an AGM, where you have the Strata register book already open. Now, on the other hand, if the Strata register book has not been opened and vacant possession is given to the purchasers, then you form a JMB. First, the JMB will run the show until, whether it's 1 month, 1 year, 2 years, 5 years, 6 years, they'll run the show until the one-fourth share units have been issued. Once the one-fourth share units have been issued, then the developer will have to call for the first AGM of the MC. He will inform the JMB about this 1 month before the first AGM of the MC. The JMB must surrender everything to the MC. And 3 months after the first AGM of the MC, the JMB is automatically dissolved. So these are two schemes that exist in our Act. One where you have developer JMB MC, the other one developer MC straight. All right.
Okay, great. Thank you so much. And we have another question from Steve, which is the question is, in the event of court case in conjunction on office bearers overstay, the court fees borne by MC or owns. Thank you.
Right. Depends on who is bringing an action and against who. Right. All If the office bearer is overstaying, they are liable and they must take the money out of their own pockets. They cannot touch the money from the management account or the sinking fund. They cannot do that. You see, if you sue the MC, that's a different thing. If you sue the JMB, it's a different thing. But if you're suing the individual office bearers because they have overstayed, then they have to bear the expenses on their own. Yes.
Okay, yep. Okay, thank you, Mr. Patrick. I think we have two last questions here. So the first one is, could management committee members and office bearers ask for allowance every month?
Answer is no. Answer is no. They cannot ask for such allowance, but they can be given reasonable out-of-pocket expenses for if they have to travel for a meeting, or there are other things that they have done. There could be out-of-pocket expenses which are allowed for them. But they cannot be given fixed allowances every month. That should not be allowed.
Okay,
Right.
understands. Okay, next question is from Spring That Time. Can an AGM proceed without an audited account be presented?
The answer would be, of course, you can proceed with an AGM, but there is liability. So if you were to look at the relevant sections, it's very clearly established. Let me just give you one example of that. In section 26, which talks about the JMB, it tells us that the joint management body shall, in respect of the maintenance account and sinking fund account, cause to be prepared such accounts, etc., etc., for the period starting from its first AGM. And they must appoint an approved company auditor to do all these things. And then it goes down to subsection 5, which says, if the joint management body fails to comply with subsections 1, 2, 3, or 4, every member of the Joint Management Committee commits an offence, and on conviction, be liable to a fine not exceeding 250,000 ringgit or imprisonment for a term not exceeding 3 years or the both. So, in that sense, if the AGM and your accounts are not presented, this is an offense. Every individual committee member is criminally liable. And of course, if he's penalized, he will automatically lose his job as a committee member. Of course, subsection 6 tells us if you can say that this was done without your knowledge and you are innocent and you have taken all precautions. For example, you may have written letters to the chairman saying that please prepare the accounts, send letters to the secretary or treasurer saying that please prepare the accounts, send letters to the secretary or treasurer saying that please prepare the accounts. All right.
Okay, great. Okay, we come into the last question, Mr. Patrick, and the question is from Felice Pang. If a developer have 30 units and 10 of their units are elected in an AGM, how many of them can be committee members in the MC?
In the MC, you're asking about the management corporation. Now, in the MC is for those who are parcel purchases and who have strata titles. In this case, the developers are entitled to be represented just like anybody else. So if they own 30 units, right, then they will have the 30 votes at the AGM. They will have their respective, if it's based on a poll, then you'll have their respective share units coming there. But if you're asking how many committee members can be there, then you'll have to pull the regulation. The regulations, that is the second schedule. If you look carefully at the second schedule, just give me a minute, I'll point out to you. The second schedule provides for a method by which it is going to be calculated. Right? It's going to be calculated. And you have to follow that method of calculation. Just give me a minute, please. You will have to look at item 2 of the second schedule. Item 2 sub 11. Okay. There is what is called a threshold number, right? There's a threshold number. This threshold number is calculated according to sub 11. It should not exceed actually 49% of the number of management committee members. The reason for this threshold number is to prevent one person, although they have many units, from dominating the entire AGM or the committee. So please do look at second schedule, item 2, sub 11. Okay, sub 10 and 11. 11 gives you the threshold number, which should not exceed 49%. All right.
Okay, great. Thank you so much, Mr. Patrick. So I think that's all for tonight. Okay, thank you so much, everyone, for coming. The second episode of the Strata Talk Show by the Excel Academy. I hope that Mr. Patrick has answered all your questions and you have a clear view on these topics, which is the management committee members, office barriers, overstaying. So thank you so much, Mr. Patrick, and thank you so much, everyone, for attending our second episode of the Strata Talk Shows. So before I end the talk show tonight, I would like to invite everyone here to attend our seminar, our next seminar on this coming, which is next Saturday, which is 23rd October 2021, by Mr. Patrick again, which he will talk about handling meetings during the pandemics. Okay, so if you like to register, if you like to attend the course, okay, you can call the numbers, our numbers stated below, which is 017 and you can register with us for the courses. Okay, so with that, thank you so much. Hope to see you guys on our next sessions. With that, take care and have a good night, everyone.
Good night, everyone. Thank you for your questions. Some of these questions are very interesting. All right, keep up with it, keep up, and we will continue to discover what the statute has to say. Good night, Encik Amir. Thank you.
Thank you so much, Mr. Patrick. Thank you so much, everyone.